5 seconds to go. Start. He therefore submits that no grounds for interference with the impugned order passed by the High Court are made out. Shrimati Prachiti Deshpande, Learned Counsel for Respondent number 2, complainant, had supported the contentions raised by the Learned Counsel for Respondent number 1. At the outset, it is relevant to mention that the son of the appellants, that is, the former husband of the complainant, was also a petitioner in the proceedings before the High Court, which were filed for quashing. He had also filed a separate special leave petition, criminal number 3298 of 2020, against the same, which had been tagged with the present appeal. However, the son of the appellants herein expired, and therefore his appeal was disposed of as abated, wide order dated 10th December 2024. In the present case, the allegations raised by the complainant in the FIR will have to be examined to find out whether the allegations, when taken at their face value, would constitute any offence or make out a case against the appellants under sections 498A, 312, 313 and 34 of the IPC. Firstly, the allegations under section 498A of the IPC must be examined. The said provision reads as under: whoever, being the husband or the relative of the husband of a woman, subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years, and shall also be liable to fine. Any wilful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb, or health, whether mental or physical, of the women, or harassment of the women where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her or any person related to her to meet such demand. The ingredients for an offence to be made out under section 498A of IPC require that there has to be cruelty inflicted against the victim, which either drives her to commit suicide or cause grave injury to herself, or lead to such conduct that would cause grave injury or danger to life, limb, or health. The second part of this section refers to harassment with a view to satisfy an unlawful demand for any property or valuable security raised by the husband or his relatives. In the present case, no allegations which would fulfill the requirement of the second part are found. A perusal of the FIR shows that the allegations made by the complainant are that in the year 2015, the appellants inflicted mental and physical cruelty upon her as she could not give birth to a male child. Such allegations made by the complainant appear to be vague, as no specific instances of harassment are mentioned. No specific role or allegation is levelled on either of the appellants, and no specific incident of physical or mental cruelty has been mentioned. A mere omnibus statement has been made that the physical and mental cruelty was afflicted because the complainant could not provide a male child. Furthermore, it is merely mentioned that the appellants would instigate the husband to harass the complainant, but again, no specific or precise instances are mentioned as to how the appellants instigated their son and what acts were committed by him as a direct result of such instigation. It would be appropriate to refer to a recent decision of this court in Criminal Appeal 5199 of 2024 titled as Dara Lakshmi Narayana and others versus State of Telangana and another. This court dealt with the ingredients of section 498A and whether the same are attracted through vague allegations raised by the complainant wife. It was observed that the issue for consideration is whether, given the facts and circumstances of the case, and after examining the FIR, the High Court was correct in refusing to quash the ongoing criminal proceedings against the appellants arising out of FIR number 82 of 2022 dated 1st February 2022 under section 498A of the IPC and sections 3 and 4 of the Dowry Act. A bare perusal of the FIR shows that the allegations made by respondent number 2 are vague and omnibus, other than claiming that appellant number 1 harassed her and that appellant numbers 2 to 6 instigated him to do so. Respondent number 2 has not provided any specific details or described any particular instance of harassment. She has also not mentioned the time, date, place, or manner in which the alleged harassment occurred. Therefore, the FIR lacks concrete and precise allegations. Further, the record reveals that respondent number 2 on 3rd October 2021 left the matrimonial house, leading appellant number 1 to file a police complaint on 5th October 2021. When the police officials traced her, respondent number 2 addressed a letter dated 11th November 2021 to the Deputy Superintendent of Police, Thirupathur Subdivision, requesting to close the complaint made by appellant number 1. In the said letter, respondent number 2 admitted that she left her matrimonial house after quarreling with appellant number 1 as she was talking to a person by name Govindan over the phone for the past 10 days continuously. She further admitted that appellant number 1 was taking good care of her. She also stated that she will not engage in such actions in future. Despite that, in 2021 itself, respondent number 2 once again left the matrimonial house, leaving appellant number 1 and also her minor children. Losing hope in the marriage, appellant number 1 issued a legal notice to respondent number 1 seeking divorce by mutual consent on 13 December 2021. Instead of responding to the said legal notice issued by appellant number 1, respondent number 2 lodged the present FIR 82 of 2022 on 1st February 2022, registered with police station Rachakonda under section 498A of the IPC and sections 3 and 4 of the Dowry Act. Given the facts of this case and in view of the timing and context of the FIR, we find that respondent number 2 left the matrimonial house on 3rd October 2021 after quarreling with appellant number 1 with respect to her interactions with a third person in their marriage. Later, she came back to her matrimonial house assuring to have a cordial relationship with appellant number 1. However, she again left the matrimonial house. When appellant number 1 issued a legal notice seeking divorce on 13 December 2021, the present FIR came to be lodged on 1st February 2022 by respondent number 2. Therefore, we are of the opinion that the FIR filed by respondent number 2 is not a genuine complaint. Rather, it is a retaliatory measure intended to settle scores with appellant number 1 and his family members. Learned counsel for respondent number 1 state contended that a prima facie case was made out against the appellants for harassing respondent number 2 and demanding dowry from her. Stop.